Ladies and gentlemen, we are starting the third session. Okay. Please take your seats. We have a 4-expert panel for this session. I would like to start with a brief update on the situation of the Polish-Russian relations. On December 12, 2004, the Russian Federation announced a new national holiday, the Day of National Unity, to be celebrated every November 4th. This new holiday replaced the communist holiday celebrated every November 7 in commemoration of the Bolshevik Revolution. Although the abolition of the communist holiday sounded like good news, it was not good news for the Polish people. It turned out that the new holiday was chosen in commemoration of the expulsion of the Poles from Moscow that took place almost 400 years ago in the year 1612. Accordingly, beginning with 2005, every November 4th, on its Day of National Unity, the Russian people celebrate the expulsion of the Poles from Moscow in 1612. In August 2010, less than 4 months after the tragic crash of the Polish presidential plane on its way to Katyn, the Polish press reported that Wasyl Blochin, the chief executioner of 6,311 Polish prisoners of war from the Ostashków camp, was honored in Russia with a brand new commemorative tombstone. A monument with the image of Blochin and his wife in one corner, the Orthodox cross in the other corner, and words "eternal memory" at the bottom. This monument was erected on Blochin's grave at the prominent Doński Cemetery in Moscow. This elegant monument stands next to anonymous mass graves with ashes of about 10,000 victims of Stalinism. It is believed that Blochin himself personally killed up to 15,000 people. In this panel session, we will be examining various attempts to administer justice for the Katyn crime. As we discuss these failures of justice, it is important to bear in mind that the rise to power of aggressive and destructive forces within Russia today is also related to the lack of resolve of the international community to name and recognize the Stalinist crimes, to condemn them in the eyes of the international public opinion, and to punish the perpetrators, but at least denying them the glory of being national heroes. It is because of this failure to condemn and correct the horrific crimes of the recent past that the people like Stalin and Blochin enjoy widespread admiration today, while the Katyn massacre, that represents one of the greatest crimes of the 20th century, is officially classified as a petty offense of exceeding official authority. In other words, not even worth prosecution. Such treatment of the Katyn crime represents a moral bankruptcy of the international community and disgrace to humanity. It also poses a real danger and immediate danger to all of us here and now. And I'm very pleased that we have in this panel very prominent speakers who would help us address the problem of Katyn. First, we will start with Professor William Schabas, Professor and Director of the Irish Centre for Human Rights and National University of Ireland. Professor Schabas traveled to our symposium today from Europe, and we are very pleased and honored to have you today with us. He's a preeminent expert on human rights and also author of many critically important publications in the international criminal law, law of genocide, and author of about 275 articles on those topics. Our next speaker is Professor Milena Sterio from the Cleveland Marshall School of Law, College of Law, from the neighboring Cleveland State University. She is an expert on international law and international war crimes. She has been publishing widely in international law journals, and she has also experience of being an international lawyer with experience in litigation and arbitration. She will be talking today about the American investigation into the Congressional investigation into the Katyn crime from 1952. Our third speaker, and we are very honored and pleased to have Dr. Alexander Guryanov, who traveled to Cleveland from Moscow, and he represents the Memorial Society, a group that is, and within the Memorial Society, Dr. Guryanov is specifically responsible for the Polish program. Dr. Guryanov will be talking about the Russian investigation in our panel. And finally, our final guest from Warsaw, Professor Janusz Cisek, a very distinguished scholar, and also director of the Museum of the Polish Army. And he has a major project to renovate the ruins of the Warsaw Citadel and the Museum of the Polish Army. He's also responsible for building the Katyn Museum in Warsaw. He's also a widely published author, and one of his very important contributions is his English language book, Polish Refugees and the Polish-American Immigration and Relief Committee after World War II. So with that, I'm very pleased to turn to our panel. Thank you.
Thank you very much. Thank you to Case and to yourself for the invitation to participate in this conference, which for myself, who is a specialist in international criminal law rather than in Polish history, was really a revelation, and was a wonderful opportunity to learn a great deal more about a subject that has been a lingering interest, but that I had never stopped long enough to tackle in a thorough way. I feel now that I'm beginning to come to grips with some of the issues. The topic, Nuremberg and Katyn, you've already heard a significant amount about. John Barrett spoke this morning, and then Steve Rapp in his lunchtime address also dealt with the question of Nuremberg. It's a dynamic relationship between the two of them, because Nuremberg is, of course, part of the narrative about Katyn and about the issue of justice for Katyn. It's the first attempt to prosecute the crime that was committed at Katyn. As we all know, the persons who were charged were the wrong suspects, and they were, in fact, acquitted, which I suppose shows that international justice does work after all. But Katyn is also part of the narrative of Nuremberg. And in our assessment of international justice, the word Katyn is frequently mentioned as a manifestation of the problem that Steve Rapp also addressed in some depth in his remarks, of the selectivity of international justice and the issue of whom we prosecute and whom we choose to leave aside. So I want to say a few words about some of these big issues that influence the debate in both of these dimensions. But first, a few words about what happened at Nuremberg. I know that John said this already, dealt with this briefly, but it's worth recalling again how the crime of Katyn was dealt with at Nuremberg. The Soviets were responsible for the part of the indictment that dealt with atrocities committed in the East. Others, the Americans, had the responsibility for the war of aggression. The division, the subject for which the Nazis were being prosecuted at Nuremberg was divided among the four powers who had created the tribunal and who had appointed the prosecutors. The four, each one appointed its own prosecutor. And Jackson later, before the Select Committee, explained that actually he was not responsible for this area, nor was he responsible, in fact, for the carriage of the case that the Soviets had decided that they wanted to prosecute. There was some quarrel as they were preparing the indictment, not just about the inclusion of the famous charge concerning Katyn, but also about references in the indictment to the territory of the Soviet Union. And Jackson said that the negotiations actually, I think he told this to the Select Committee, that they almost failed to agree upon an indictment because of his refusal to go along with language that would appear to recognize Soviet hegemony and so that Soviet territory included the three Baltic states. He made a reservation to this. The reservation also refers to other territory, but it doesn't go beyond that. The Soviets, of course, insisted on including the reference to Katyn in the indictment. Jackson later said that he quarreled with them and objected to it, although I think it's fairly clear from his testimony and from the other reports about the preparation of the indictment that it wasn't so much about a conviction on the part of Jackson and others that the Soviets were actually responsible for Katyn. Jackson explained and gave a number of reasons for not including it in the indictment. He said that, first of all, we didn't need to include it in the indictment. This is something that we can discuss, but he said we already had lots of evidence of massive atrocities committed by the Nazis against the Polish people, and we actually didn't need to add that part to it. He also said, and I think there's a certain amount of wisdom in his remarks, he said it was going to be difficult to prove in one way or another because it was something that was going to require eyewitness testimony. And he said we had very little eyewitness testimony at Nuremberg. Most of the case was actually built on documents. And in the entire trial, on the prosecution side, there were in fact only 33 witnesses called in the Nuremberg case. Most of the case was made on documents. And he said this was going to be very hard to prove. There's an interesting comment at the very end of the trial by one of the prosecutors, Robert Servatius, who was the counsel to, not the prosecutors, one of the defense lawyers. He was the counsel to Fritz Sackel, his name was, one of the Nazi defendants. And he just gave Katyn as an example of the difficulty of getting to the bottom of the facts when the investigations had been so political. And by the time they got to Nuremberg, of course, you had charges on one side or another from the Nazis and from the Soviets, both of which were profoundly suspect. Nobody was going to easily accept the Nazi Commission of Inquiry any more than they were going to view the Soviet Commission of Inquiry as being entirely neutral and objective and disinterested. So for all these reasons, Jackson said he opposed including it, but the Soviets insisted. Later, it became clear that they were very half-hearted about it, and they may very soon have regretted that they raised the issue at all. When they produced evidence in February of 1946, it was confined to a few minutes, and it was essentially the production of the report of the Soviet Commission, which went in as an exhibit for the Soviet Union, exhibit number 50. This, of course, stirred the Nazi defense lawyers who said that they wanted to call evidence to challenge this, particularly Goering's lawyer. And so the judges, with great reluctance, agreed that they would hear more evidence on the case. The Soviets objected. They said that there could be no challenge to their report. Jackson said, again before the Select Committee, that their position, the American position, was, of course, the Germans were entitled to call evidence on the other side. And this is interesting, the handling of it, because I think it shows also the profound fairness of the proceedings at Nuremberg. This was not a one-sided trial. The Soviets would have liked it to be that way. I think they thought that the trial might have run rather like some of the trials they had in the Soviet Union in the 1930s. But in fact, the judges and the other prosecutors were not going to let that happen. And so in July of 1946, as the trial was ending, in the final days of the trial, approximately 2 days were devoted to the calling of evidence. Today, when we read that evidence, and I reread it yesterday on the plane flying over from Ireland, when we reread that evidence, we have difficulty dissociating it from what we know today about Katyn, including, of course, the admission by the Soviet Union, by the Russians, that they were responsible for it. But I think a criminal lawyer or a judge reading that evidence today, in the absence of knowing other material about it, and the judges did not apparently have anything else to go on. They were not certainly supposed to take into account anything other than what had been tendered in evidence, would walk away scratching their head saying, I don't know what to make of this. You had 3 witnesses called by the German defendants. The 3 witnesses who testified for the German defendants essentially said, we were there at Katyn in 1942 and 1943, and we didn't see anything. We didn't hear anything about an order to murder people. And while that may be a very accurate account of what they knew, it hardly goes to it's hardly a compelling way to address a problem that's been put there on the table to simply say, we deny it. They did not, in their evidence and with their 3 witnesses, try to set out their case that the Soviets had done it. They simply said, we discovered the bones there, we discovered the remains. They did not, for example, produce their report, the report of the commission that the Germans had set up in 1943, and it's not an exhibit at the Nuremberg trial. Then the Russians came along, and they produced their 3 witnesses in reply. And their witnesses were also weak and ineffective, and I think a good lesson to a prosecutor about what not to do to try and prove a case, because the evidence that the German lawyers had failed to put on the record, including portions of the report that had been of the commission that the Germans had set up in 1943, actually got into the record through the Soviet witnesses. And the Soviets, I think, actually helped to make the case against themselves. But in the end, I think the testimony of those 6 witnesses, 3 for the Germans and 3 for the Soviets, is simply inconclusive. And perhaps it's unfortunate that the judges in the final judgment did not say this explicitly. Instead, they're entirely silent on the subject. But the result finally is, in many ways, the proper one. They were not there to assign responsibility to the Soviet Union. They had no jurisdiction to do so, and they didn't have enough evidence before them to make that step. In any case, it would have been reckless and hazardous, I think, on their behalf to do that. So instead of saying that the evidence was inconclusive, they were simply silent on the matter. And that includes, and then I think perhaps if we ever get to know everything about it, which we surely will not do, one might even say that it may have shown some courage on the part of the Soviet judge not to mention this in his dissenting opinion as well. He wrote a dissenting opinion, and he might very well have used that as the occasion to say that in his opinion the Germans were responsible and should have been convicted, and instead he was silent. And many people have pointed to this, saying how that shows the nature of the trial, really, when it came to dealing with Katyn. Now, what has all this done for the legacy of Nuremberg, and also for the history of our understanding of the prosecution and the legal issues related to Katyn? I want to make 3 brief observations or remarks about this. The first is about what it does for the historical record. There is now quite a literature, very interesting discussions about the role of international justice in establishing the historical record. The Nuremberg judgment and the trial proceedings themselves, but the judgment specifically, is an extremely important part of history. It clarifies historical truth. It's a record of historical truth. It shows the shortcoming of using judgments to clarify historical truth, because there are parts of the historical truth that the judgment can't get at easily, including, of course, the crimes committed by those who are not being prosecuted, in this case, Katyn. But it's not the only one. One of the references I came across in my research was in a document called the Butler Memorandum. The Butler Memorandum is a document prepared by a historian in the British Foreign Office, I think in the 1970s, or perhaps later, based on the documents in the British archives dealing with Katyn. And the document can be located on the internet. In that memorandum, he cites various components of the way that the British were dealing with Katyn during the trial at Nuremberg, and in particular notes that after the Soviets tabled their evidence in February of 1946, the British ambassador in Tehran wrote to the Foreign Office in London and said, as far as he was concerned, the Russians had done the deed. The Russians had done it. And then there was an exchange of notes within the British Foreign Office, and instructions were sent out to the British prosecutor at Nuremberg on how to deal with the matter. One of the very interesting things in that documentation is a memo from one of the British diplomats to the file saying that maybe it was better that they dealt with Katyn and that they got a judgment against the Germans so that it could all be laid to rest. A great, wonderful example of a cynical bureaucrat who sees this as an opportunity not to write history, but to distort history, to create a dishonest historical record. And again, it's to the credit of the judgment that it doesn't do that. It leaves it unsaid. Second issue of interest, I suppose, to legal historians. I don't know if it's of any interest to the people who are really concerned with the Katyn issue as such. But to those of us who work with international law and the work of international justice, the Katyn issue is fascinating for what it tells us about how the prosecutors operate. Contemporary prosecutors, I'm talking about the present-day institutions, have provisions written into the statutes of their tribunals saying that they are to be independent and to take instructions from no one. Steve Rapp will remember the provision in the statute of the International Criminal Tribunal for Rwanda when he was working there, and I don't believe anybody, well, there have been allegations that various prosecutors were in fact receiving orders from different places, but I don't think they're credible, and I don't think any serious person gives them any substance. But at Nuremberg, it was not the case. The 4 prosecutors at Nuremberg were in fact representing their governments, and they were taking instructions. I've always wanted to know much more about this, about how that came out and the kinds of instructions they were getting. And we get bits of insight into this in the documentation about Katyn, although I'm sure there's a great deal we don't know. One thing that we would love to know would be how much the Soviet prosecutor knew about it. Was the Soviet prosecutor in on the lie? Did he know that the Soviets had done it? Or was he simply basing himself on the official doctrine that was coming out from the Soviet authorities? I don't know that we know that. We don't know the kinds of instructions that he would have got. Justice Jackson, in his testimony before the Select Committee, spoke to this a little bit, and he was asked directly, did he get instructions? And I'm quoting now from page 1954 of his testimony. He says that they ask if he did get instructions on this, and he says, no, as a matter of fact, I received very little instruction from anybody. The thing was a lawyer's job, and I had no instructions. If I may be so blunt as to say so, I thought that having once gotten me into it, there was a pronounced disposition to leave everything to me. He may not have been getting any instructions. I'm not sure that the same can be said of his deputy, Wild Bill Donovan, who was actually there representing U.S. military intelligence. And there have been some fascinating studies now about the connections between the intelligence establishment and the role of the prosecution team, and not Jackson himself, but those who were working with him. And in that famous Butler memorandum, there's very definite evidence of instructions going out from the British Foreign Office to the British prosecution team at Katyn. And they essentially told them, don't do anything, don't help the Soviets, this is their problem, just sit it out and watch. And there were suggestions, also during the Select Committee, that the prosecutors may have helped the Russians make their case on Katyn. If they did a poor job, because as I've just explained, the actual evidence the Soviets put into the record is quite pathetic. There's one little incident in the final day of testimony when one of the Soviet witnesses, this is the Bulgarian forensic Markov, the forensic pathologist who testifies and who had been on the German team doing the investigation. And he's cross-examined by Göring's lawyer, who suggests that he's reading and that he had a written text for his testimony in chief that was in fact given to the interpreters. And before the cross-examination resumes, Thomas Dodd, later Senator Dodd, intervenes to save the Soviet witness by saying that he had checked with the interpreters and they didn't have such a document. So there was a wee bit of help given to the Soviets as they made the case from Senator Dodd. The final point, and this is really about what Katyn has done to the narrative, to our understanding of Nuremberg. Katyn is usually raised in the context of the victor's justice critique of Nuremberg. It's the idea that Nuremberg was profoundly flawed because it only prosecuted one side. Jackson explained to the Select Committee, he was quite correct, that the tribunal at Nuremberg had no jurisdiction to prosecute the Soviets and to make a finding of guilt with respect to the Soviets, even if they had the evidence to do so. But in many, many comments about the Nuremberg trial, people say this was a one-sided prosecution, and Katyn is only one of the examples that's given, by the way. Frequently, the critiques of Nuremberg include reference to the bombing of German cities by the British and the Americans, and the role of Churchill and others in the decisions to firebomb these cities with terrible loss of life. The bombing of Hiroshima and Nagasaki by the Americans with the atomic bomb and the terrible destruction that brought about. The submarine warfare issues, it's a subject for a whole other conference about this two-sided prosecution, and I think that Steve Rapp in his remarks admirably discussed the various dimensions. I had intended to go into a little more detail on this, but I don't think I need to do so. In his comments, I think what Steve left us with, though, was a question mark as to how to do this. Because the justice is, I think, I totally agree with his hesitation and his comments about this and the difficulty of it. I think I agree that the idea that we solve it by some mechanistic decision to prosecute both sides, as Carlo Del Ponte had suggested, is not the way to proceed. And in my assessment of the Rwanda Tribunal, it has never seemed to me to be outrageous that the prosecutor decided in his wisdom that he wasn't going to prosecute the RPF cases. That was, I think, in many ways a legitimate decision based on the policy of the tribunal and on the relative assessment of the importance of the crimes. And when it's said, as some do about the Rwanda Tribunal, that the failure to prosecute both sides is an obstacle to reconciliation, I have to say that while that sounds very attractive, very seductive as a rationale, I'm not convinced, and I don't see any great evidence for it. Speaking of Nuremberg as a whole, and maybe setting aside the particular problem of Katyn, would prosecuting the Allies, would prosecuting the Americans for bombing Hiroshima and Nagasaki, or for submarine warfare, or prosecuting the British, would this have brought us closer to reconciliation after the Second World War? I don't believe that. I think, I want to say, just because the stop sign has come up now, I just have another sentence or two. But I want to say in as much as I can give a conclusion, and I will try to write this up in more detail, that I'm a great fan and a great enthusiast of Nuremberg. I would hate to see frustration with the issue of Katyn and justice for the victims and the survivors of Katyn used as an issue to tarnish the great accomplishment of the Nuremberg trial. Nor am I at all of the view that Nuremberg was flawed or failed because there were not even-handed prosecutions on the other side. What would we have done? Had a second tribunal with 23 American defendants and a third, and German judges, by the way, and then a third tribunal with 23 British defendants and German and Japanese judges? I don't know that would have brought us closer to justice. I think that the problem actually with international justice, and it's a lingering one, maybe it's even more acute in a place like the International Criminal Court, where we have to choose not just the defendants in a given situation, but we have to choose the situation to go and prosecute, is that these are decisions with a great political dimension to them. They have an inevitable political dimension, and yet we leave them to prosecutors. And I think that's perhaps too big a burden to put on their shoulders. Thank you.
Thank you. Like Bill Schabas, for me as well, it is a great pleasure to be here, and I think Maria has done a tremendous job in organizing this conference, along with Michael Scharf, as usual. And I'm really proud to be here in a sense that Katyn also was new to me. I had found out about it about 10 years ago when I learned about it from a Polish-American friend in a private conversation that had nothing to do with international law or Polish history per se. And it was a huge surprise to me to learn about this. Now, I work and research in the field of international law and international criminal law, so like I will echo exactly what Bill said, and that is that I'm not an expert in Polish history, but preparing for this conference, I've certainly done a lot of research and learned a lot, and I'm very happy to be here today. Now, I will focus on the so-called Madden Committee, the Madden Committee investigation, which was a U.S. Congressional investigation in 1952 into the Katyn crime. However, before I get there, let me just give you a few brief facts setting the stage for the Madden Committee investigation. First of all, and many other speakers here have spoken about this already, but historical accounts show that the Allies, Great Britain and the United States, knew about Katyn. So, for example, there are historical records that indicate that Winston Churchill, in a private conversation in 1943, said the following about this allegation that the Soviets were actually responsible for the Katyn killings. He said, "The German revelations are probably true. The Bolsheviks can be very cruel." However, of course, publicly, he disavowed this information and embraced the stance that really it had been the Germans. Now, similarly, Roosevelt at the time, there are accounts that showed that he also knew about Katyn. Roosevelt had sent George Earl, who was his special emissary to the Balkans. He had sent George Earl to investigate Katyn, to find out what had happened. Now, George Earl concluded in a report to Roosevelt that the Soviets were actually responsible for the massacre. However, in a private conversation between George Earl and President Roosevelt literally says, "No, George, that's just not true. It can't be true. The Germans didn't really do it." When George Earl later asked basically whether he could publicize his findings, President Roosevelt firmly said no. He actually even issued a written order to desist to George Earl, and later basically had George Earl transferred to American Samoa for the remainder of World War II. Now, as punishments go, spending a couple of years in a tropical island does not sound very harsh to me. Nonetheless, George Earl was really eliminated from this situation. Further, there are two American prisoners of war, Donald Stewart and John Van Vliet, who had been captured by the Germans during World War II and were purposely taken by the Germans to Katyn and showed these mass graves. And it was part of this German propaganda effort to show, look, it really wasn't us, it was the Soviets, look how bad they are in a sense. In 1945, at the end of World War II, Van Vliet authored a report in which he concluded that the Soviets were responsible for the massacre. He then gave this report to his superior, Major General Clayton Bissell, and General Bissell destroyed the report. Now later, General Bissell had claimed that he had actually transferred this report to the State Department. He tried to produce evidence that he had actually done so. He produced these letters showing that, in the letters he sort of refers to this, but he could not produce any definite proof that he had indeed transferred the report to the State Department. And the Madden Committee actually looked into this. I'll come back to this in just a couple of minutes. All of this shows that the United States, as well as Great Britain, had significant information to indicate that the Soviets were indeed responsible for the Katyn killings. Yet, at the time, because of fear of alienating the Soviet Union during World War II, the United States, as well as Great Britain, chose to publicly disavow this information and to officially blame Germany. Now, fast forward to 1950, 1951, and John Barrett has already spoken about this a little bit, but basically the political climate in the United States had changed significantly. The Soviet Union, which had been a powerful ally, a friend during World War II, certainly towards the end of World War II, had turned into a powerful enemy. This is now the height of the Korean War, the Cold War. We had McCarthyism here in the United States. The Polish-American lobby was gaining some strength, and so the United States Congress formed this committee comprised of several congressmen and chaired by Congressman Ray Madden to look into the events at the Katyn Forest. Now, the Madden Committee actually spent a significant amount of time looking into this. They spent more than a year working on this. They interviewed dozens of different witnesses basically around the world. They traveled to Germany, they went to England, they went to many different places. They talked to a lot of people. They looked at a lot of evidence. And they produced first an interim report and later a final report. Now, the final report is a public document. Anybody can find it basically on the internet very easily these days. It's interesting to note the Madden Committee requested, they asked several governments as to whether they would cooperate, with the investigation. The Soviet Union obviously declined, and so did Poland at the time. Now, of course, the Polish government at the time was under, a huge, influence of the Soviet Union. This is the Cold War, and the Polish government certainly did not have much autonomy at the time to stand up to the Soviet Union and say, actually, no, we're going to, to work with the Madden Committee. So Poland and the Soviet Union at the time did not work with the Madden Committee. Now, what are some of the things that the Madden Committee did and concluded here? And let me just highlight some of the most relevant findings here. So the Madden Committee in the interim report, which came first before the final report, also in 1952, said that the Katyn crimes were in violation of the general principles of law recognized by civilized nations. It's a very significant finding, and it's pretty amazing that really nothing significant happened after this until many, many decades later. Another finding of the Madden Committee, it says, it is apparent that American authorities knew of the growing tension between the Soviets and the Poles during 1942-1943, and they likewise knew about the hopeless search for the Polish officers. But at the time, all of these factors were brushed aside on the theory that pressing the search would irritate Soviet Russia and thus hinder the prosecution of the war to a successful conclusion. That's also another official finding of the Madden Committee. Now, finally, the Madden Committee recommended, in its sort of ultimate finding, recommended that the matter be referred to the International Court of Justice and that the World Court should now follow and investigate these matters. Now, the political will at the time was lacking, and nothing was really done. I'll come back to this in just a second. Let me just mention some of the important witnesses that testified before the Madden Committee, one of which was Major General Bissell. Now, Major General Bissell was the individual who had destroyed the so-called Van Vlad report in 1945. Now, General Bissell appeared before the Madden Committee and attempted first to defend this claim that he had somehow transferred the Van Vlad report to the State Department. Now, the Madden Committee does not come out and say he lied about it, but they basically say, we conclude that he was mistaken in this statement that he had transferred the report to the State Department, basically concluding, no, actually, he had destroyed the report. And General Bissell actually testified before the committee and said, in a sense, I was right to destroy this report because at the time, Russia, the Soviet Union rather, was an important ally, and I could not risk embarrassing us or embarrassing them. We really needed them for the end of World War II. We wanted to involve them in this effort to fight Japan to the end. And so I destroyed the report. And he doesn't really say I was right, but ultimately, if you read between the lines, that's essentially his claim. Now, another very important witness that the Madden Committee, who testified before the Madden Committee, was actually Justice Jackson. So John Barrett spoke at length about Justice Jackson, and Bill Schabas had also mentioned Justice Jackson. Justice Jackson was basically, he appeared voluntarily before this committee, so he chose to come and testify, and he was questioned on this issue of that there were allegations that the Americans at Nuremberg had actually helped the Soviets prepare these claims against the Germans for Katyn. How basically Justice Jackson's staff had, collaborated with the Soviet prosecutors to bring this case forward against the Germans. And Justice Jackson basically says, no, I didn't do anything. We didn't purposely do anything. And then when questioned on whether if he had been provided direct information about the Soviet, responsibility for Katyn, he responded the following. He said, "Of course, any information would have been helpful. If we had had information of that kind, I cannot pass on whether this would have been adequate, but if we had adequate information of Russian guilt, we would not have consented at all to have the charge against the Nazis. It would have strengthened our hand in keeping it out immensely and probably would have resulted in the Soviets not making the accusation." Furthermore, Justice Jackson made another statement, which I think John Barrett had already referred to. He said, "This history will show that if it is now deemed possible to establish responsibility for the Katyn murders, nothing that was decided by the Nuremberg Tribunal or contended for by the American prosecution will stand in your way." And I would also like to echo what Bill Schabas just said about the legacy of Nuremberg, how even though, I know this is a very difficult issue, and I know it's quite astonishing that nothing was done on Katyn for so many decades. I think it would be a shame to tarnish the legacy of Nuremberg on this issue. So I wholly, support what Bill Schabas just said. Now, just to come back to the Madden Committee and its final report. So despite the fact that there was this conclusion there how the issue should be referred to the International Court of Justice, that basically the Soviets were responsible, nothing was ever done about this. Why? Well, at the end of the investigation, the political will to do anything was lacking basically anywhere. At the end of the Korean War, there was somewhat of a thawing between the U.S. and Soviet relations. So diplomatically speaking, obviously bringing this up would have been embarrassing. The United States basically, our government didn't do much for, many, many decades. And it wasn't really until 1991, and the end of the Cold War when the Soviet and then the Russian government started basically, accepting partially its responsibility for Katyn, because the experts here can correct me if I'm wrong on this, but the Russian government has basically never accepted responsibility for all of the killings. They have accepted responsibility for some of the killings, but the numbers do not really match. So it wasn't until 1990, 1991 that academic conferences like this one started being organized, that academic research started being done into Katyn, that some memorials were starting to be erected. And even though let me just refer to the title of this conference, Justice Delayed versus Justice Denied. I would argue that justice delayed is still better than justice denied. And Congresswoman Kaptur said, maybe we're rewriting or completing history here today. If that's the case, then I'm extremely proud to be here in this room with all of you in this effort to rewrite or complete history. Thank you.
Esteemed ladies and gentlemen, my topic is not strictly the Russian investigation, but rather the current status of Katyn case in Russia. But first of all, I would like to offer my thanks to the organizers for invitation to this conference and for giving me the honor of speaking to you as a representative of Russian Memorial Society. And I am sorry very much for my poor English. The Memorial Society, in addition to its activity in defending human rights in Russia today, also conducts the study of the history of political repression in the Soviet Union, documenting the fate of repressed people and assisting their moral and legal rehabilitation. And another statutory task of the Memorial Society is to promote access to sources of information about the crimes of totalitarian regimes. By education, I am not a historian and certainly not a lawyer, but I work at the research center of Memorial, and I am engaged in last year. I am engaged in studies of the history of Soviet political repression against Poles and Polish citizens. In addition, in last year, I have to deal with some certain legal issues as one of the representatives of our society in proceedings of some aspects of the Katyn case before the Russian courts. Already several years, Memorial Society is seeking the realization of measures at the state level, without which a legal resolving of Katyn case in Russia is impossible, in our opinion. These measures, this is firstly the adoption of the adequate legal qualification of the Katyn crime, corresponding to its essence as the act of Soviet state terrorism. Second, the procedural establishment of all perpetrators, starting with those who decided on the massacre of thousands of Polish citizens, and finishing with all the ordinary performers of extrajudicial executions. None of them are no longer alive, so they cannot be put before the court, but their names must be disclosed. This is our opinion. Third, the recognition by name of all prisoners of war and regular prisoners who were shot in the Katyn massacre as the victims of the political repression in accordance with existing current Russian law on the rehabilitation of victims of political repression. And fourth, the declassification of all materials of the Katyn massacre investigation conducted by the Russian main military prosecutor's office from 1990 to 2004. Before presenting the current state of affairs in this regard, I would like to remind you how changed the official position of the Soviet Union and Russia for Katyn case. Since the autumn of 1941 to March 1943, Soviet authorities claimed that they know nothing about the fate of Polish officers captured by the Soviet captivity in September 1939. After the announcement by the Germans in April 1943 about the discovered graves of shot Polish officers in the Katyn forest, Soviet authorities until April 1990 claimed that the execution was carried out by the Nazis, who allegedly captured in the summer of 1941 three Soviet camps for prisoners of war near Smolensk, in which Polish officers were kept. The final report of Special Burdenko Commission, designated in the very beginning of 1944 to investigate the shooting of Polish officers, this report was intended to provide the visibility of legal basis for lying Soviet official version. The evidence which the Burdenko Commission had relied on subsequently proved to be fabricated. The evidence and the testimony, eyewitness testimony. Only in April 1990, under President Mikhail Gorbachev, the Soviet Union has acknowledged guilty Beria, Merkulov, and their henchmen of committing a massacre of Polish prisoners of war. In the official statement of governmental TASS agency, their execution was described as one of the serious crimes of Stalinism. In the autumn of 1990, the Soviet main military prosecutor's office began to investigate Katyn massacre. After the Soviet Union disintegration, the investigation of the criminal Katyn case was continued by the Russian main military prosecutor's office. In October 1992, Russian President Boris Yeltsin directed to make public the document showing that the extrajudicial execution of Polish citizens had been carried out on the orders of the Soviet leadership, Stalin personally, and 5 other members of the Politburo of the Central Committee of the Communist Party. However, this political position did not find then its legal expression. Official legal position has been formulated only on September 21st in 2004, when the main military prosecutor's office dismissed the criminal Katyn case for the death of the guilty, and simultaneously classified the investigation materials as secret and top secret, including the very decision, the very resolution to dismiss the case. This was announced publicly only after 6 months, in March 2005. Referring to the secrecy established by itself, the main military prosecutor's office refused to announce the perpetrators by name, saying only that they were a few leading officials of the NKVD, Soviet secret police. Their actions being qualified under paragraph B of Article 193-17 of the Penal Code, Russian Penal Code, valid in 1940, namely as the excess of authority that had adverse consequences in the presence of specially aggravating circumstances. Thus, the main perpetrators, Stalin and Politburo members, were excluded from the circle of persons responsible for the Katyn massacre. And the extermination of thousands of Polish citizens were qualified as an ordinary crime that is subject to a 10-year statute of limitations. From the persons responsible for the shooting were also excluded all performance of operation to shoot 22,000 Polish prisoners of war and arrested persons, except a few, the leaders of the NKVD. Only one explanation of this may be possible. The contemporary Russian main military prosecutor's office does not consider carrying out of a criminal order as a crime. In 2005-2006, the main military prosecutor's office completed its legal position that, in contrary to the requirements of the existing current Russian law on the rehabilitation of victims of political repression, refused to consider the question of recognition of each individual shot prisoner of war as a victim of political repression. Main military prosecutor's office refuses to recognize not only a political motive, political reason, but even the very fact of execution of each individual prisoner of war, referring that the individual documents about the shooting were not preserved. It means, while not denying the fact of mass executions of Polish prisoners of war, the main military prosecutor's office seeks to save them as a multitude of nameless, anonymous victims. Thus, the official legal position in the short term is this: the investigation terminated, the materials being classified, the Katyn massacre is qualified as ordinary crime that occurred a long time barred. Guilty are only a few leaders of NKVD, but not Stalin with the other members of Soviet leadership. And finally, the victims of the shooting are not subject to rehabilitation. After March 2005, attempts were made to influence the formal legal position. Applications for rehabilitation in accordance with the law on the rehabilitation of victims of political repression of a number of individual shot Polish prisoners of war were submitted to the main military prosecutor's office. Applications for rehabilitation of 16 of them were submitted in 2006 by the Memorial Society as the first step to roll by name rehabilitation of all those executed by the decision of the Politburo of the Communist Party taken on March the 5th, 1940. Applications for rehabilitation of 10 more victims of execution were filed by their relatives, including the son of one of the shot prisoners of war who lives in the USA. The relatives were represented in Russia by Moscow lawyers Anna Stavitska and Roman Karpinsky, acting independently of the Memorial Society. Refusals of the main military prosecutor's office to execute the Russian law on the rehabilitation in relation to individual shot Polish prisoners of war were appealed by the Memorial Society and independently by other claimants in the Russian courts of first, second in Russian cassation and the supervisory instances, the Khamovnichesky District Court of Moscow, the Moscow Military District Court, the Moscow City Court, the Presidium of the Moscow City Court, the Supreme Court of the Russian Federation. Family members of executed prisoners of war, in addition to the rehabilitation of their relatives, demanded to cancel the decision of the main military prosecutor's office to dismiss the criminal Katyn case, to reopen the investigation, to acknowledge the status of victims for them in accordance with the with Russian Criminal Procedure Code, and to give them the opportunity to get acquainted with case materials. All of the above named courts, on behalf of Russian Federation, denied to meet the complaints, thus confirming the legal position of the main military prosecutor's office as the official position of Russia. As a result, the Memorial Society and independently other applicants were forced to turn to the European Court of Human Rights in Strasbourg to complain about a violation by Russia of the European Convention on Human Rights and Fundamental Freedoms. Currently, the European Court considers as a priority the claim of 10 families of executed Polish officers. The complaint of the Memorial Society is awaiting their turn to examine. Next, in 2006 and 2008, the Memorial submitted to the main military prosecutor's office the request to declassify the key document of the Katyn case investigation, namely the resolution on its termination. According to the Russian Criminal Procedure Code, the resolution to dismiss a criminal case must contain in short form all the results of the investigation. Memorial consider the classification of this important document as the first step to open all the closed materials of the Katyn case investigation. Memorial refers to Article 7 of the Russian law on state secrets, according to which classification of information about violation of human rights and freedoms of man and citizen, as well as information about violations of law by governmental authorities and their officials, is prohibited. The refusal of the main military prosecutor's office to perform the procedure assigned by law on state secrets was appealed by the Memorial in Khamovnichesky District Court of Moscow. Unfortunately, this court of first instance and then the Moscow City Court, in which the Memorial filed a cassation appeal, found no violation in the actions of the main military prosecutor's office. In 2009, the Memorial Society turned to Russia's highest state authority in the area of secrecy, namely the Interdepartmental Commission for the Protection of State Secrets, the activity of which is supervised by the President of Russian Federation. Memorial demanded to cancel the decision on classifying the resolution to dismiss the criminal Katyn case. The refusal of the Interdepartmental Commission was appealed by Memorial to Moscow City Court, which in November last year, 2010, ruled that the actions of the main military prosecutor's office and the Interdepartmental Commission to classify the resolution of termination were legitimate. Despite the flagrant violations, in our opinion flagrant, of the Civil Procedure Code committed by the Moscow City Court, the Supreme Court of the Russian Federation on 26 January this year, a week ago, upheld the decision of the Court of First Instance. Thus, now the Memorial Society is faced with the need to send a supervisory complaint to the Presidium of the Supreme Court of the Russian Federation concerning the illegality of the classification of key material of Katyn case, as well as the next complaint to the European Court of Human Rights. Here we must note the two particular features of the Memorial Society's application to the courts. First, although the Memorial Society does not reject the possibility of recourse to international justice, but we would really like to achieve the solution of Katyn case in the Russian courts, because the Memorial considered the Katyn case primarily as an internal problem of Russia itself, and even then as the problem of Russian-Polish relations. Secondly, appeals on Katyn case filed by Memorial in the Russian courts and the European Court of Human Rights formally are the complaints of violation of the right of the Memorial Society itself to carry out its statutory activities and to its right for a fair trial. This is the difference from the court cases brought by relatives of shot prisoners of war, who complain of a violation by Russia their own rights as victims. Meanwhile, last year in 2010, however, aroused some new situation. After 70 years of silence, the Russian authorities at last articulated its political position concerning the Katyn massacre. The start was even before the tragic crash of the Polish presidential plane near Smolensk. In spring 2010, firstly Prime Minister Putin and then more definitely President Medvedev have publicly voiced his opinion about Stalin's culpability in the massacre of Polish citizens. In the statement of the Russian Parliament, State Duma of the Russian Federation, taken on November the 26th last year, it was for the first time made public the official recognition by Russia of the personal responsibility of Stalin and his associates as the main perpetrators of Katyn massacre. In 2010, copies of 137 of the 147 volumes of unclassified materials of Russian investigation of Katyn criminal case were handed over to Poland, but none of the other 36 secret or top secret volumes has not yet been declassified and handed over. But the press office of President Medvedev has sent a comment about the recent decision of the Supreme Court of the Russian Federation. This comment is to ensure that the declassification of Katyn case materials is going on, and after finishing, the copies will be transferred to the Polish side. Formally, there is no contradiction. The recognition of declassification being legal in the past does not preclude the declassification in the present time. So despite the recent decision of the Russian Supreme Court, some slip of Russia's official position may occur, at least on the declassification. In general, the political declaration on Katyn case are welcome, but the contradiction between the statements of Russian authorities and the legal position of the main military prosecutor's office, unchanged since 2004, has now become more striking. While the legal position of the Russian state will not be aligned with political declaration, Katyn case in Russia cannot be considered as closed. Thank you for your attention.
Ladies and gentlemen, my presentation is about the Katyn investigation by the authorities of the Republic of Poland. Of course, such an investigation was impossible prior to 1991 for political reasons. In July of 1991, the auxiliary Polish investigation, which served as an adjunct to the Soviet National Military Prosecutors' investigation, was initiated. Pursuant to a decision by the then Justice Minister Aleksander Będkowski, Stefan Śnieżko was appointed coordinator. Notwithstanding the Soviet investigation, which was underway, and in light of the decision dated September 2nd, 1993, by Justice Minister Piotrowski, steps were undertaken to initiate an independent Polish investigation into the Katyn massacre. A number of individuals from the Warsaw Prosecutor's Office were designated to work in this unit, which was in receipt of materials previously in the possession of Mr. Śnieżko, and they were charged with the responsibility of organizing and conducting the Polish Katyn investigation. The unit was headed by the prosecutor Aleksander Herzog. This specific unit was later dissolved, and the materials in its possession were transferred to the Instytut Pamięci Narodowej o Institute of National Remembrance in January 2000. In making the decision to initiate the Polish investigation, it was agreed that by sanctioning the Katyn massacre, USSR government officials involved had committed an illegal act which included a deliberate operation to execute thousands of Polish prisoners of war and civilians, which act, as understood by international law and convention, was a war crime and crime against humanity. There exist multiple goals in the above referenced investigation, which include a unified and comprehensive documented explanation of the circumstances in this matter, including, among other issues, a detailed listing of the names of all the Polish citizens who were victims of the Katyn massacre, determination of heretofore unknown massacre and burial sites of these victims, ascertaining the names of all those involved in making the decision dated March 5, 1940, as well as the names of those involved in execution, the decision, and determining the scope of a responsibility, and finally bringing the still living perpetrators to justice insofar as it is possible. Another goal is the formation of a complete list of those who are defined as injured as a result of the loss of their family members as based on Polish law. Investigatory process case number S34/04K. An investigation was conducted by the Interdepartmental Investigative Unit, which was dissolved by order of the Director of the Chief Commission of the Prosecution of Crimes against the Polish Nation, a division of the IPN, in 2008. It was replaced by a 3-member investigative unit consisting of prosecutors from the Chief Commission working on case number S38/04ZK. The work of this specific unit is aided by the remaining 10 regional commissions, which aid the Chief Commission by conducting interviews of witnessing parties in their respective regions. Documentary efforts of the investigative process concentrate primarily on interviewing witnesses both in Poland and abroad, as well as locating archival material which refers to the Katyn massacre. As a result, a total of 2,589 witnesses have been questioned, with the greater majority being immediate family members of the victims. Among those recently reviewed, it is particularly relevant to mention the testimony of Henry T., who related that he was transported as a forced laborer to Smolensk in February 1942, and that in the spring of 1943 he was an eyewitness to the exhumation conducted in the Katyn forest. This testimony, as well as other items referred to in this presentation, has proved that despite the passage of 70 years, new materials and evidence continue to be discovered. International cooperation. Cooperation with the ministers of justice of Russia, Ukraine, and Belarus is of great importance in the investigators' work concerning the Katyn massacre. Cooperative endeavors with the Russian Federation. Because of its great import for the prosecution, the documentary evidence collected in the investigation recorded as case number 159 of the National Military Prosecutor of the Russian Federation with respect to the Katyn massacre, the Regional Commission of the Chief Commission in Warsaw, through the good offices of the Polish Ministry of Justice, submitted a request that the Prosecutor General's Office of the Russian Federation extend all possible legal aid and assistance. This included a request for verified photocopies or copies of the completed prosecutorial documentation found under number 159 in the records of the National Military Prosecutor of the Russian Federation, and additionally for a verified photocopy or copy of the decision to suspend said investigation and the transfer of all aforementioned documents to the All Russian Workers' Party dated March 5, 1940, concerning the murder of the Poles. The Russian side did not allow for photocopying of the documents that had been reviewed, nor was the entirety of the case material made possible, with this decision being based on the statement that a portion of them were designed as secret. This designation was also applied to the decision dated September 21st, 2004, suspending investigation number 159, and this designation precluded, despite the repeated request of the IPN prosecutors, its review. On September 30th, 2009, the Regional Commission in Warsaw forwarded a second request through the Ministry of Justice to the prosecutorial offices of the Russian Federation, in which it requested once again for legal assistance on criminal case number S38/04ZK by making the entirety of the National Military Prosecutor's case files referencing case number 159, as well as the decision concerning the suspension of the case, the verified photocopies of the entirety of the investigation, as well as the decisions of the suspension of the investigation and concurrence for the transfer of all documentation concerning this case available for review by the Polish investigators. In May of 2010, the Russian Federation transferred the 67 volumes of materials which had been previously reviewed, while in September an additional 20 volumes and in December a final 50 volumes were received. In total, 137 volumes of materials concerning the Polish prosecutors was transferred. The response of the Prosecutors General of the Russian Federation dated June 28, 2005, which was transmitted through the offices of the Ministry of Justice of the Republic of Poland, was received by the IPN on July 28, 2005. The reply advised that the Russian side would make available 67 volumes of case material referencing case number 159 of the Military Prosecutor General's Office of the Russian Federation. This correspondence did not clarify why all the material would not be made available, nor was any reference made to the possibility of the Polish side receiving a copy of the Civilian Prosecutors General's investigatory materials and a copy of the determination which terminated investigation number 159. At the invitation of Military Prosecutors General Office of the Russian Federation, and during the period of October 9, 2005, 3 prosecutors representing the IPN Regional Commission in Warsaw, as well as the chief specialist of the Chief Commission, visited Moscow. During the course of their visit, they were able to acquaint themselves with the materials contained in the 67 volumes referencing case 159 that had been made available and made appropriate documentary notations. Nonetheless, this work did not lead to the acquisition of any essential information about the Katyn massacre and not increase the available information about the subject matter. The documents made available did not include the criminal edict of the Politburo to the Central Committee of the investigation of case number 159, while another 36 volumes considered to be top secret have not been transferred. Cooperative endeavors with the Republic of Ukraine. On August 18, 2005, the Regional Commission in Warsaw also requested that the Prosecutor General of the Ukrainian Republic assist with legal efforts on the ongoing investigation. Specifically, reference was made to the materials gathered by the Ukrainian prosecutors in 5 cases, but particularly in case number 50-0092 Bukovnia, concerning the discovery of mass graves in the Bukovnia forest in Kiev Oblast, which the Polish prosecutors wished to review. The Prosecutor General of the Ukrainian Republic extended an invitation to the 3 IPN prosecutors as well as the chief specialist of the Chief Commission who were able to work in the Kiev office during the period of November 5, 2006. This visit enabled the group to familiarize themselves with 22 volumes of procedural documentation from the Ukrainian Military Prosecutor's Office in the Kiev region, number 500092, in the case of the mass graves in the Dnieper forest of the Bukovnia near Kiev, the investigation of which was suspended by decree of June 25, 2001. They were also able to review the contents of 35 volumes of case material of the execution of Polish officers and Polish civilians in 1940-41 by the NKVD of the USSR, governed by the Ukrainian Military Prosecutor's Office in the northern region. This investigation is not concluded. As advised by the Ukrainian Military Prosecutor's Office in the central region, it is conducting preliminary procedures in this case. In August 2007, through the good offices of the Embassy of the Republic of Poland in Kiev, the Regional Commission in Warsaw received a selection of materials gathered in the 22 volumes, which each volume consisting of several hundred pages. During the course of the proceedings, a request was sent in April 2007 to the Prosecutors General of the Ukrainian Republic regarding legal assistance by sending a verified photocopy of what is referred to the Ukrainian Katyn list. That is a list of 3,435 Polish citizens who had been detained in prisons in what is referred to the Western Ukraine and who had been executed as a result of the order dated March 5, 1941. The subject list was submitted for use in the investigatory process, reference as S3804ZK in August 2007. Cooperative endeavors with the Republic of Belarus. In September 20, 2002, the Minister of Justice of the Republic of Poland submitted a request to the Minister of Justice of the Belarusian Republic in which they asked for a determination as to whether the prosecutor of the Belarusian Republic had conducted an investigation into the matter of the mass graves in Kuropaty near Minsk, and for a copy of the evidence thus collected. Based on the reply received in 2003 from the Belarusian Republic, it appears that during the course of conducting the case in the matter of disclosing the identities of those individuals buried in the Kuropaty forest preserve in the Minsk region, the nationality and citizenship of the exhumed skeletal remains was not determined. Thus, the Belarusian side did not release any photocopies of the materials involved in this case. In response to the Russian decision to terminate the Katyn investigation, the Polish Parliament on March 22, 2005, adopted a resolution expressing regret that the Katyn crime became politicized in order to downplay its significance and to evade responsibility for the crime. The resolution stated, "We expect from the Russian nation and from the Russian Federation the clear admission of the genocidal character of the murder of Polish prisoners of war as defined by the Nuremberg trials. We also expect that all circumstances in this crime will be revealed, in particular the location of the burial of a large number of murdered prisoners whose graves have still been impossible to locate. We express our disappointment that the Katyn investigation has been terminated by the prosecutorial authority of the Russian Federation. We expect that all the documents from the Katyn investigation will be released. The Sejm of the Republic of Poland expresses its support of the Institute of National Remembrance to conduct the investigation into the Katyn crime and considers its necessary to continue activities so undertaken. Cooperative endeavors with other nations. A request for legal assistance was also issued to the Ministry of Justice of the Republic of Germany. As a result, the Regional Commission in Warsaw conducted research in the subject matter in designated German archives. Photocopies of documents were received from the Prosecutor General in Koblenz, Rhine Region Palatinate, which originated in the political archives of the Foreign Ministry in Berlin and the Federal Archive in Koblenz. Additionally, the German Foreign Office wrote suggesting that the need for a personal review by the IPN prosecutors of the archival material contained in the political archives of the Ministry of Foreign Affairs in Berlin, which review was conducted on July 1922, 2005. These documents were transferred as microfiche copies by the Germans to the Regional Commission in Warsaw. With respect to conflicting information as to the contents of the Soviet documentation of Smolensk, which was captured by the Germans in the summer of 1941 and which was transferred by them to the Reich and then was seized by the Americans, a decision was made concerning the necessity of conducting research on the issue of the Katyn massacre in these materials. Despite the passage of decades, the investigation continuously unearths new material about documents in foreign archives. In November of 2007, detailed information was received about the research results of the queries conducted in London by IPN archivists concerning Katyn in the archives of the Polish Institute and General Sikorski Museum and the Polish Underground Movement Study Trust, also in London, and the Polish Library. What was clear was that there was a large amount of material which might have significance in the investigation of case number S3804ZK, the selective archives of the Polish Institute and the General Sikorski Museum consisted of 321 items and over 1,000 pages, mostly in the Polish language. An important source of information for the investigation will, with certainty, will be the expansive documentation accumulated by the Select Committee to conduct the investigation of the facts, evidence, and circumstances of the Katyn Forest Massacre of the 82nd Congress. Steps have been undertaken through the offices of the Embassy of the Republic of Poland in the United States to determine the extent of the documentation and the possibility of reviewing it by the National Archives in the United States. In May of 2009, the Polish Ministry of Justice, acting on behalf of the IPN, submitted a request for legal assistance in the subject matter to the Authority General of the Republic of Poland. There are some other institutions and persons cooperating in this investigation, including Mrs. Krystyna Piórkowska, who is present in this hall, and she was able to locate several important documents concerning, for example, German interpreter Georg von Johnson, who was in Katyn, and also South African Colonel Frank Stevenson, who was in Katyn in 1943. Thank you for your attention.
I guess we have a couple of minutes for questions, so please, we have a microphone here. Any questions? Yes, please. Can you
George Earl was not sent to investigate the Katyn massacre. George Earl was a minister to Bulgaria and Austria and a special emissary to the Balkans. In that role, he was in contact with individuals from the Balkans, and in his testimony, he clearly states that he received materials from 2 Bulgarians and 1 Romanian who had had personal contact on the issue of Katyn. And he states that in their reports, which were given to him in Istanbul, they declared their presence in Katyn during the investigation. This would lead to the understanding that these 3 individuals were Dr. Berkle, Dr. Markov, who later testified on behalf of the Soviets, and Dr. Miloslavich, all members of the International Commission. Earl was never sent to investigate, and he was functioning in a completely different role. And it is clear that Earl, in his correspondence with Washington, had to write to Roosevelt's daughter because of Harry Hopkins' influence. The second thing I would state is that it was not Bissell who attempted to justify himself on the basis of papers that he submitted during the testimony in front of the Madden Commission. Rather, Bissell was handed documentation that had been received from the State Department, and on that correspondence, the cover letters to the Van Vliet memo and the cover memo of August 45 to the Gilder memo, he clearly, the Madden Commission representatives found notations which were cipher numbers entered by the State Department when they received a document. And there were cross-references to the Van Vliet report there. And this is a heretical position on my part. However, it is not my belief that this will destroy the report.
Okay, thank you very much for your comment. Please use the microphone. We need to use the microphone. Okay. Yes, please.
For Dr. Guryanov, I'm Henry Sokolowski with the Kresy Siberia and Polish Combatants Associations in Toronto. I read in the newspaper quite a few months ago that the Russian authorities have been harassing the Memorial Society. There was a report of some computers being confiscated or files taken away. If that report is true, is the harassment continuing, and how are you dealing with it?
Moment.
They've always been harassed.
Ну, я не слышал об оскорблениях.
Well, he really doesn't know anything about harassment.
Ну, вот за последние 4 года у нас состоялось более 40 судебных заседаний по нашим обращениям в связи с Катынским делом.
For the recent 4 years, there were more than 40,
Более 40.
more than 40 hearings concerned with the Katyn case, and
Нам не удалось выиграть ни одного нашего дела.
we didn't succeed. We didn't win on any one of those cases.
Но можно ли это назвать оскорблением со стороны российского правительства? Ну, я сомневаюсь.
I don't think that I can call it harassment from the Russian authorities. It cannot be called harassment.
Okay. And Marco, yes, please. Yes, sure. Professor
I think just in response though, you were talking about a different part of Memorial's has quite a few responsibilities, and the St. Petersburg branch in I think it was December of 2009 had its offices raided by the local authority, the FSB, you know, the state security, and they later did, through the courts, regain those files. But the harassment was evident, and similarly, the head of Memorial, more recently, as a result of comments made last year in connection with Ramzan Kadyrov, the head of Chechnya, whom he accused of complicity in the murder of a Russian journalist, and most people do think that is the case. But as a result of that, he too has come under harassment. So some parts of Memorial clearly have been harassed. But Alexander's investigation, I think, is what he was addressing.
Any more questions? Yes, please.
Thank you. I'd like to say that I found your comments very enlightening and informative. I've enjoyed this afternoon as well as this morning's presentations. I'm a little bit surprised that none of the speakers has mentioned or addressed the fact that Poland had a 10-year peace treaty, 1934, when Pilsudski was still alive, as well as with Germany, that ran for 10 years from 1934. Secondly, no one has brought up the March 1939 guarantee by Neville Chamberlain's government following Munich, when Joseph Beck and the Polish ambassador to Great Britain met to sign this guarantee that guaranteed Poland's sovereignty and borders unconditionally. That these men, these officers, reserves as well as active officers, were the representatives of a legitimate sovereign government who was at peace with the Soviet Union on September 1st, 1939, as well as beyond. And there's also the interesting question, why did France and Great Britain declare war only on Nazi Germany? Nobody ever declared war on the Soviet Union after the Soviet Union invaded Poland on September 1939 from the east. Thank you very much for a very informative and enlightening program.
And with that, we will conclude our session, third session of this afternoon, and 15-minute break.